Hello there. Thank you for joining Mayer Brown's Technology Transactions Practice webinar. Our program today will focus on preparing your vendor agreements for the GDPR. I will cover a couple of administrative matters and then we'll get started. We will be scheduling periodic calls and webinar programs on technology transactions topics, so watch your inboxes for future invitations and feel free to spread the word to others who might be interested. You can also find many past programs on the Technology Transactions webpage at www.mayerbrown.com. Our goal is to provide practical and strategic advice to help you secure high-value technology contracts, improve operations, build digital platforms, and achieve compliance. During today's presentation, you will be provided with an alphanumeric code. If you are applying for CLE credits, you will need to record this code on the virtual sign-in sheet that you will receive by email with the connection details. You will find directions for returning that virtual sign-in sheet on that sheet. We'll read the code in the middle of the presentation and then again at the end. There may be time at the end of the program for questions. To submit a question electronically, please use the Q&A panel in the WebEx. If we don't get to answer your question during the webinar, we will make every attempt to follow up with you after the webinar. The webinar is being recorded, as we normally do with these programs. In a day or so, we will be sending you an email with a link, which you can use to listen to the webinar again or share with your colleagues. The recording will also be posted to our website. My name is Oliver Yaros, and I'm delighted to participate with my colleague Lei Shen on today's topic. I'm a partner in Mayer Brown's London office, and I advise clients on TMT outsourcing, IT, data protection, e-commerce, and IP transactions and issues. I'm pleased to introduce my fellow presenter, Lei Shen. Lei Shen is currently a senior associate in Mayer Brown's Chicago office, but from the 1st of January, she's going to be a partner. Lei Shen focuses her practice on data privacy and security, technology and business process outsourcing, and information technology transactions. With that brief introduction, let's get started with today's program. So, the topics we're going to cover today. First of all, we're going to speak in a little bit of basic detail about the building blocks of data protection. I'm going to spend some time talking about what the new requirements are under the GDPR, as well as provide an overview of the recent guidance that's been provided by the Article 29 Working Party and the other data protection authorities in Europe. We're then going to spend some time talking about what businesses should expect and how they should prepare for the GDPR generally. And then Lei is going to spend a lot of time talking about how organizations should be reviewing and updating their vendor agreements to ensure compliance with the GDPR, particularly in light of recent developments and guidance. So, the data protection basics. Data protection law in the EU is currently governed by the European Data Protection Directive 1995 as it is implemented in the EU member states. So, for example, in the UK, that is implemented by the UK Data Protection Act, and in other European countries, there are other national laws that implement it. There are a number of key terms you need to know to understand the way in which European data protection law has to be complied with. The law applies to personal data. That's information that can be used to identify living individuals. It applies to processing of personal data. Processing is anything that can be done to personal data, storing it, disclosing it to somebody else, receiving it, accessing it. The data controller is primarily the entity that is responsible for complying with data protection law. The controller makes decisions about how personal data is used, whereas the data processor is an organization that has been appointed by a data controller to process personal data on its behalf. So that may be a service provider or other similar third party. Processor typically doesn't have any discretion about how it may use the personal data. It has to use it for the purposes that have been required by controller. And then finally, you've got the data subject, who is the individual who the personal data is about. Data protection law is regulated and supervised by national data protection authorities in each European country. And there are sanctions for non-compliance, including criminal offences and civil fines. Now for an overview of the changes that are coming into force under the General Data Protection Regulation. The General Data Protection Regulation will be coming into force as of the 25th of May 2018. So the first change is that the GDPR is a regulation, not a directive. What that means is that the GDPR will be directly applicable in the same form throughout all EU member states without any national implementing legislation. That means it should be pretty much the same law that applies throughout Europe. There's a change in the territorial scope, and I'll explain about that in a moment, but essentially what that means is that organisations outside the EU will also have to comply with the GDPR in particular circumstances, as well as those that are inside the EU. There are significantly higher fines that could be issued for failing to comply with European data protection law. So the highest fine that could be issued could be the higher of either 20 million euros or up to 4% of an organisation's worldwide turnover, whichever is higher, so a much larger figure than currently. There's also a data breach notification obligation. So where an organisation loses personal data, they've got to notify the relevant data protection authority without undue delay, and where feasible, within 72 hours of becoming aware of it. And where they haven't met that obligation, they've got to explain why they haven't done that. Individuals may also have to be notified of security breaches in some circumstances as well. There are significant amounts of data privacy governance requirements that have to be complied with. And that is really to reflect this new requirement of implementing privacy by design and by default, which is really the purpose of the GDPR, to make sure that organizations are thinking about data protection, thinking about people's privacy rights at the outset of doing something with personal data, and documenting how decisions about data are made and how the risks to individuals are minimized. There are going to be stronger rights that individuals are going to have to their personal data, and there are going to be obligations on both controllers and processors, and there will be requirements which controllers have to impose on their processors when entering into contracts with them. And that is the main part of this webinar, which Lei Shen will be covering later on. Just a quick overview of some of the other key changes. So I mentioned that territorial scope is changing. In the past, European law had to be complied with when the organisation was established in the EU and processing in the context of that establishment, or was using equipment in the EU to process personal data. But the GDPR is expanding the scope of European data protection law. Now, any processing that is in the context of an establishment in the EU, whether it's carried out in the EU or not, has to comply with European data protection law. And any organisations that are outside the EU that are offering goods or services to individuals in the EU, or are monitoring their behaviour in some way, whether that's by profiling individuals or whether that's by tracking their behaviour online or in other respects, are going to have to comply with the GDPR as well. So organisations that are based outside of the EU that historically haven't had to think about the way in which they deal with personal data about individuals in the EU that they have received directly are now going to have to rethink how they comply with European data protection law. I mentioned earlier on that there are some new data privacy governance requirements One of those requirements is to appoint a data protection officer if certain criteria are met. So organisations that are processing sensitive personal data on a large scale, so information about people's health conditions, information about people's criminal convictions, information about ethnicity or race or sexual orientation or trade union membership, political beliefs, to the extent an organisation is doing that on a large scale, or to the extent that an organisation is carrying out regular or systematic monitoring of individuals on a large scale, such as using CCTV, for example, those organisations are going to have to appoint a data protection officer. It may well be that organisations, because of the processing activities that they're doing, will want to appoint a data protection officer in any event. Lots of organisations do. But it's important to note that appointing a data protection officer brings with it some obligations about the independence of that data protection officer, about the requirement that they have expert knowledge of data protection law. They've got to have a direct report to the highest management level of the company, and they've got to be responsible for monitoring and ensuring data protection compliance within their organisation. There are data governance requirements that have to be complied with respect to documenting how an organisation deals with personal data. So both controllers and processors have an obligation to create a record of the personal data that they are processing. That's a record of the types of personal data they have, how they're using it, what they're using it for, who that data is about, who that data is being shared with, how long it's being kept for, whether it's being sent internationally outside of the EU, and how that data is being secured. It's important to create that record and to maintain it. So a lot of organisations will be going through a process to create that record. Where there is processing activity that's likely to be high risk to the privacy rights of the individuals, it's important to do a further analysis of a data protection impact assessment. And what that means is conducting a process where you review whether a processing activity is really required, how the privacy rights of individuals may be affected, and how any of those those risks may be mitigated. And it's generally completed by way of a risk register. There are particular types of processing that will automatically require a DPIA to be performed. That's where you are using CCTV on a large scale, where you are processing sensitive personal data, where you are conducting systematic or extensive evaluation of individuals, i.e. profiling them. But there are other factors as well that may require a DPIA to be conducted, particularly if two or more factors from guidance that has been issued are met. Factors include things like conducting international transfers of data, using combining data sets or matching data sets. There are other activities as well that may lead organisations to conclude that activities are high risk and warrant conducting a DPIA. There are also changes to the grounds that can be relied on to process personal data, as well as the information that has to be provided to individuals about how their data is being used. So you have to rely on at least one legal ground to process personal data. The titles of those legal grounds aren't changing, but some of the ways in which you satisfy them will be. So, for example, to the extent your organisation relies on consent to process any personal data, you've now got to demonstrate that the consent is informed, unambiguous, and freely given by an indication, by a statement or clear affirmative action of consent. It's no longer going to be good enough to bury consents in long terms and conditions or agreements that you send out to individuals. It's now going to have to be given in a separate box or a separate area of a form, and it's going to have to be signed, or there's going to have to be an affirmative tick to demonstrate that someone's given their consent. the situation in which someone has been asked for their consent will also be considered to work out whether consent has really been given. If the performance of a contract is conditional on consent being given and that information isn't really needed to perform a contract, then it is likely that consent has not been freely given. Legitimate interest, which is a ground that a lot of organizations rely on to process personal data, that is also changing a little bit in that to be able to demonstrate that legitimate interests can be relied upon, you've actually got to inform individuals about what the legitimate interest is that you are trying to pursue. And that leads on to the notice requirements that you've got to comply with when collecting personal data from individuals to ensure that you can use it. So there is an obligation to tell individuals not just who you are and what you're doing with the personal data, but what legal grounds you're relying on to process that personal data, who you're going to be sharing that personal data with, whether that information is going to be transferred outside of the EEA, and if so, what legal mechanisms are going to be used to allow you to do that. You've also got to tell people about how long information is going to be kept for, or the criteria they're going to be used to work out that period. You've also got to give people a description of their rights under the GDPR, and you've also got to inform them of any automated decision-making or profiling that's going on with respect to their data. So the chances are that the information that you've collected from individuals up till now, you may not have provided the notices that you need to provide to individuals under the GDPR to allow you to continue using that information post 25th of May next year. So reviewing those notices and refreshing those notices is something that organizations are going to have to consider doing. I mentioned that there are enhanced rights that individuals will have to their data under the GDPR. At the moment, individuals have a right to access their personal data, to be given a copy of it, or to be told what personal data you've got on them. They also have a right to be forgotten, to have data about them which you hold erased in certain circumstances. Under the GDPR, that right to be forgotten is solidified. It's in the GDPR explicitly, but also there are other rights as well. The right to ask for a copy of your data that can then be taken to another party or a competing entity, for example. The right to data portability is a new right. There are also enhanced rights to object to any profiling or automated decision-making that organizations might be doing on individuals. In terms of latest developments, there has been, over the last 6 months, a reasonable amount of guidance issued by the data protection authorities in Europe. There is the Article 29 Working Party, which is the data protection authority for Europe. It's a collection of all the DPAs within the EU. There is the UK Information Commissioner's Office, there is the French CNIL, and there are other data protection authorities that have issued guidance. And over the last 6 months, it has addressed a number of topics, including what would constitute high-risk processing and when you should be conducting a data protection impact assessment, what contracts between data controllers and data processors should contain and how liabilities between them should be divided up, and Leigh will talk to that in a moment. There's been guidance issued about how fines would be issued. There's been guidance issued about the circumstances in which security breach notification would be required. And there's also been guidance issued on automated decision-making and profiling and how that can be done in compliance with the GDPR. We do expect over the remaining period before May of next year additional guidance to be issued by the Article 29 Working Party, by the ICO and by others, and we hope that helps give further clarification about how some of these requirements in the GDPR should be complied with. If you've got any questions about the guidance that's been issued up to now, do let us know. But in the meantime, you should be thinking about how you should be preparing to comply with the GDPR. We've summarized it in our 10 steps, and hopefully you are far along with these steps. As you can see, step 9 is to review your supply chain contracts to ensure your service providers will comply with the GDPR, and a connected step with that is to review the international transfers of personal data that's being conducted by your business. There will be suppliers that you're dealing with who are based outside of the EU. You may also be outside of the EU, so working out how you get data to them is very important. And that is the subject of the remaining part of this webinar.
So now we'll cover how you should be updating your vendor or processor agreements to ensure that they will comply with the new requirements under the GDPR. First, it's important to understand some key changes that GDPR has made with respect to processors and their obligations and liabilities. Under the current EU directive, the data controller has the primary obligation to comply with EU data protection law. The directive requires the controller to have a contract in place with its processors that contains certain obligations, but the controller is the one that's ultimately responsible for any breaches by the processor. Under the EU directive, the data protection authorities don't actually have any direct enforcement powers over the processor. So if the DPA does take any enforcement action, it would do so against the controller, and the processor would then be contractually liable to the controller. This will change under the GDPR, though. Under the GDPR, processors will start having direct obligations and liabilities outside of the terms of the contract with the controller. In other words, the GDPR directly imposes specific obligations on data processors, rather than just requiring the controller to include those obligations in the contract. Therefore, if a processor breaches those obligations, then it will be directly liable under the law, and a DPA can go after that processor directly rather than having to go through the controller. This also means that processors, in addition to controllers, may be liable to pay damages or be subject to corrective measures, and more importantly, be subject to the GDPR's large fines. Some of these new direct processor obligations include the obligation to cooperate with a supervisory authority, the obligation to implement appropriate technical and organizational security measures, the obligation to maintain records of processing activities, the obligation to notify the controller in the event of a data breach, the obligation to comply with cross-border data transfers, among other obligations. In addition to these new processor obligations, DPAs can also go after a processor if the processor acts contrary to the instructions of the data controller. Specifically, the GDPR states that if a processor infringes the law by determining the purposes and means of the processing itself, meaning it's not following the controller's instructions, then it will be considered to be a controller with respect to that processing and therefore be liable accordingly. The GDPR also has specific requirements for controllers with respect to their processors. First, the GDPR requires that controllers only select processors who have sufficient guarantees, in particular in terms of expert knowledge, reliability, and resources to implement technical and organizational measures that will meet the requirements of the GDPR. A new method that the GDPR adds for demonstrating compliance is a code of conduct or a certification mechanism. If a processor adheres to a code of conduct or certification mechanism that has been approved for the GDPR, then that may be used by a controller to demonstrate compliance with this requirement. So far, no such codes of conduct are currently available. Second, the GDPR requires that parties have an adequate data transfer mechanism in place if it is transferring data out of the EU and to a country that is not considered by the EU to have adequate data protection laws, such as the United States. We'll also cover this later in the presentation. And third, similar to the EU directive, the GDPR requires that contracts with processors contain certain obligations for the processor. However, the GDPR does require certain obligations to be included in these contracts that were not required by the directive, which we'll discuss next. Both the EU directive and the GDPR require the controllers to include specific obligations in their contracts with data processors, but the GDPR introduces some key changes to these obligations. Under the EU directive, the processor contract needed to include two obligations: the requirements for the processor to act only on the instructions from the controller, and the requirement for the processor to implement appropriate technical and organizational security measures. The GDPR retains these two contractual requirements from the directive, but adds several other requirements. These new requirements are aimed at ensuring and demonstrating compliance with all requirements of the GDPR, rather than just those related to keeping personal data secure. Also, these contractual requirements from the controller are in addition to the new direct processor obligations that we discussed earlier. We'll discuss these new requirements in more detail in the next slide, but some of these requirements include certain record-keeping requirements and restrictions on subcontracting. As a result of these additional requirements, most vendor agreements are going to require some modifications. In addition, there is no grace period, meaning vendor agreements will need to meet the new requirements by May 25th, 2018, when the GDPR goes into effect. So how should you be updating your vendor agreements to comply with the GDPR? As we mentioned earlier, the GDPR requires specific provisions to be included in your agreements with your vendors, a number of which were not required by the EU directive. These are covered by Article 28 of the GDPR. First, your vendor agreement should set out the following higher-level items: the subject matter of the processing and the duration of the processing, the nature and purpose of the processing, basically what kind of processing is being done by the vendor, the type of personal data and the categories of data subjects, and the obligations and rights of the controller. These are all higher-level provisions that may already be covered by your agreement or can be included in an appendix, similar to what's included in Appendix 1 to the standard contractual clauses. The purpose of these first few points is to be clear from the outset about the extent of the processing that you are contracting out. The GDPR also requires specific terms to be included in the contract. First, the contract must state that the vendor will only process personal data on your documented instructions, including with regard to transfers of data to a third country. Now, this requirement is very similar to the current requirement in the directive that a processor only act on instructions from the controller. However, these instructions must now be documented or written. The intent of this provision is to make it clear that it is you, rather than the processor, who controls what happens to the personal data. The contract must also require the vendor to ensure that all the people that it has authorized to access the personal data have committed themselves to confidentiality or are under an appropriate statutory obligation of confidentiality, such as an attorney. This is a new obligation that wasn't included in the EU directive, but most agreements should already contain confidentiality provisions that require their vendors to keep their data confidential, so this new obligation will likely not require an update. It's important to note, though, that this obligation covers not only the vendor's employees, but also any temporary workers or agency workers who have access to the personal data. Next, the vendor must be required to implement appropriate technical and organizational security measures. This requirement to have security in place is already included in the EU directive, but the GDPR expands on this some more. Specifically, Article 28 requires processors to take all measures required pursuant to Article 32 of the GDPR, which spells out various security requirements. According to Article 32, the processor must implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk, and taking into account various factors, including the nature, scope, context, and purposes of the processing, and the various risks involved. So you might want to require that the vendor use specific technical measures, such as pseudonymization or encryption, depending on the type of processing or personal data that's involved. Interestingly, this requirement to have appropriate security measures in place is both a direct processor obligation under the GDPR, as well as an obligation that the controller must include in the contract. Next, the vendor must also not engage another subprocessor without your consent. Specifically, the vendor cannot engage another processor without either your specific or general written authorization. If you provide general written authorization that allows the vendor to use subcontractors, then the vendor must inform you of any intended changes concerning the addition or replacement of those subcontractors, with the goal being to give you the opportunity to object to those changes. If the vendor does engage a subprocessor, then the vendor's contract with that subprocessor must contain the same data protection obligations as are required by Article 28. In particular, the subprocessor must be able to provide sufficient guarantees to implement appropriate technical and organizational security measures that meet the GDPR's requirements. In addition, if the subprocessor fails to meet its obligations, then the original processor, or the vendor, will be fully liable to you for that failure. This means the vendor cannot absolve itself of responsibility by using a subprocessor. And as with the requirements above, this subprocessing restriction is both a direct processor obligation under the GDPR, as well as an obligation that the controller must include in the contract. The vendor must also provide assistance to enable you to comply with data subject requests. Specifically, Article 28 states that, taking into account the nature of the processing, the processor must also assist the controller by appropriate technical and organizational measures for the fulfillment of the controller's obligation to respond to requests for exercising the data subject's rights. So the vendor's data processing should be set up so that it can help you respond to and fulfill data subject requests. Since the vendor is the one that's handling the personal data regularly, its cooperation in helping data subjects exercise their rights is going to be essential. Most of the data subject rights under the GDPR already exist under the EU directive, so if you are already subject to the directive, this may not be a major change with respect to these existing rights. However, the GDPR does add some new data subject rights, such as the right to be forgotten and the right to data portability, that may require you and the vendor to make changes to your respective systems and procedures in order to comply. The vendor must also provide assistance to you to enable you to comply with your obligations in Articles 32 to 36 of the GDPR, which cover security requirements, breach notification requirements, data protection impact assessments, and consultations with a supervisory authority. This means your vendor should assist you in meeting your obligation to keep data secure. In the event of a data breach, your vendor should assist you with your obligations to notify your supervisory authority and affected data subjects as applicable. Your vendor should also assist you in carrying out DPIAs and should assist you in meeting your obligation to consult with the supervisory authority if a DPIA indicates that there is an unmitigated high risk to the processing. We should also note that the vendor's duty to assist here isn't unlimited, but is rather limited by taking into account the nature of the processing and the information that's available to the vendor. And a note on data breach notification. The processor is already directly required by the GDPR to notify you without undue delay after becoming aware of a data breach, but you should still consider including this obligation in your agreement as well. If you're already subject to U.S. data breach notification laws, you may already have a similar requirement in your agreement for vendors to notify you in the event of a breach. And we'll analyze this requirement in further detail in a later slide. The contract must also require the vendor to, at your choice, either delete or return all of your personal data to you at the end of the provision of the services, or basically at the end of the contract, and delete existing copies of the personal data, unless EU law requires the vendor to retain that personal data. This obligation would include data in the vendor's backups and archives as well. So if they're required to retain that information by EU law, then they should continue protecting that information in accordance with your agreement and be required to delete or return it as soon as that obligation to retain it ends. The vendor must also make available to you all information necessary to demonstrate their compliance with the obligations mentioned here, and allow for and contribute to audits, including inspections that are conducted by you or another auditor appointed by you. Finally, the vendor must also tell you if it thinks it has been given an instruction that doesn't comply with the GDPR or other EU law. In addition to the obligations that the GDPR specifically requires to be included in the contract with the processor, there are other GDPR obligations that you may want to consider adding or updating in your vendor agreement as well, such as some of the direct processor obligations, even though the GDPR doesn't specifically require you to do so. One of these is definitions. Some of the definitions from the EU directive have been updated in the GDPR, and some new definitions have been added. For example, the definition of personal data now includes location data and online identifiers, and also references genetic factors. The definition of sensitive personal data, or special category personal data, has also been updated to reference genetic data or biometric data, as well as sexual orientation. There's also a new definition of genetic data that's been added. Therefore, if your vendor agreements have directly copied in these definitions from the EU directive, or if genetic data is involved, then you should consider updating or adding those definitions accordingly to match the new definitions under the GDPR. Record keeping. You may want to add that the vendor is obligated to maintain a record of the categories of processing activities that it's carrying out on your behalf, and make such records available to you or supervisory authority upon request. This is a direct processor obligation under Article 30 of the GDPR, so you should still consider adding it in your agreement. You may also want to require that the vendor comply with cross-border data transfer requirements, such as entering into standard contractual clauses with you. DPO requirement. Consider whether the vendor is required to have a designated data protection officer. Again, this is a direct processor obligation under the GDPR, but you may want to add it depending on the vendor. Data protection by design. Depending on the type of processing or services that the vendor is providing to you, you may want to consider specifically requiring the vendor to implement data protection by design or to assist you in doing so. If you are Privacy Shield certified and the vendor is receiving an onward transfer of data that you received under the Privacy Shield, then you will need to evaluate the vendor agreement to ensure it's compliant with the Privacy Shield onward transfer requirements, specifically the requirements under the Accountability for Onward Transfer principle. You may also want to review the indemnities, limits of liability, or other similar clauses in your agreement to address the new risks brought about by the GDPR, including the substantially increased fines, such as in the event of a data breach. And finally, the UK's ICO also recommends in its recent guidance that the vendor contract state that nothing within the contract relieves the vendor of its own direct responsibilities and liabilities under the GDPR, and also reflects any indemnity that has been agreed. As Oliver mentioned, some DPAs have started releasing guidance on how to update your vendor agreements. As I mentioned on the prior slide, the UK's ICO recently released draft guidance in September on contracts and liabilities between controllers and processors. Francis Conneal has also issued guidance in September, but from a processor's perspective rather than a controller's perspective. While both documents provided basic guidance on the Article 28 requirements, they also left out a lot of unanswered questions. For example, they did not address how far down the subprocessor chain a processor needs to flow down its Article 28 obligations. Without specific guidance, it's assumed that all agreements in the entire subprocessor chain must comply with the Article 28 requirements if those subprocessors will have access to the personal data. They also did not address agreements with other controllers, such as joint controllers or certain liability considerations. Hopefully, we'll receive future guidance on these that will address these questions in the future. Now, one of the biggest changes and challenges under the GDPR is the new data breach notification obligation for both controllers and processors. Under the directive, several EU countries already have data breach notification requirements in place, such as Germany. And other countries have issued guidance that strongly encourages businesses to voluntarily report data breaches. But even for these EU countries that already have similar requirements in place, the GDPR poses more stringent requirements. There are 3 different breach notification requirements under the GDPR, 2 for the controller and 1 for the processor. First, the controller must report to a competent supervisory authority without undue delay and, where feasible, not later than 72 hours, unless the breach is unlikely to result in a risk to data subjects. In that report to the supervisory authority, the controller must describe the items listed here: the nature of the breach, such as the categories and number of data subjects and the categories of personal data, the name and contact information of the controller's DPO or other contact point where more information can be obtained, the likely consequences of the breach, and measures that the controller has taken or proposed to address the breach. Now let's contrast this with the U.S., where the quickest notification obligation is 30 days, which is already really hard to comply with. So to comply with the 72 hours requirement, it's extra important to have a data breach response plan in place and to practice that plan so that you can react promptly if there is a data breach, and also to conduct data mapping so that you know what is in the affected system. Now, you don't have to provide all of this information within that 72 hours if that information is not available yet. The GDPR does permit you to provide that information in phases. The Article 29 Working Party states that you should indicate to the supervisory authority that you will be providing more information at a later point. And the supervisory authority should agree how and when additional information should be provided. However, if you don't notify the supervisory authority within 72 hours, then you will need to justify your delay for notifying. The second notification obligation for controllers is to notify affected data subjects without undue delay if a breach is likely to result in a high risk to those data subjects, which is a higher bar for notification than the notification obligation to the supervisory authorities. Now, what's considered to be high risk to data subjects? Recital 85 of the GDPR and the Article 29 Working Party describe this as when the breach may lead to physical, material, or non-material damage to individuals whose data has been breached, and in particular where the breach may lead to discrimination, identity theft or fraud, financial loss or damage to reputation, unauthorized reversal of pseudonymization, or the breach involves personal data that reveals racial or ethnic origin, political opinion, religion or philosophical beliefs, or trade union membership, or includes genetic data, data concerning health or data concerning sex life, or criminal convictions and offenses or related security measures. In addition, the Article 29 Working Party recommends taking into account the following factors to assess the level of risk to individuals: the type of breach, the nature and sensitivity and volume of personal data, the ease of identification of affected individuals, the severity of the consequences for the affected individuals, whether there are any special characteristics of the affected individuals, such as if there are children or if there are other vulnerable individuals, the number of affected individuals, and special characteristics of the data controller, such as if it's a medical organization. The notice to data subjects will need to include similar information as the report to the supervisory authority. And you might be able to avoid notifying individuals if you are able to show that the data is unintelligible, such as through the use of encryption, or that the risks have otherwise somehow been mitigated. However, you'll still need to document any reasoning for not notifying any data subjects. The processor's notification obligation under the GDPR is much broader than the controller's notification obligation. While the controller had a risk analysis involved for both of its notification obligations, there's actually no risk analysis that applies to the processor's obligation. The GDPR simply states that the processor shall notify the controller without undue delay after becoming aware of a personal data breach. This makes this obligation very broad. This means that the processor needs to notify the controller in the event of any breach of personal data. The controller would then apply the risk analysis to determine if it in turn needs to notify a supervisory authority or the affected data subjects. The Article 29 Working Party recently came out with draft guidance on how to respond to data breaches, which I've discussed in this section, but there are a few points from that guidance I'd like to highlight that might be of concern. First, the Article 29 Working Party states in this guidance that a controller is considered to have become aware of a breach when the controller has a reasonable degree of certainty that a security incident has occurred that has led to personal data being compromised. It notes that in some cases, it will be relatively clear from the outset that there has been a breach, whereas in others, it will take some time to establish if personal data has been compromised, such as after a short period of investigation. Now, this is relatively in line with U.S. data breach notification laws. However, if the controller uses a processor to process personal data and the processor experiences a breach, Then the Article 29 Working Party states that, in principle, the controller should be considered as aware once the processor has become aware. Based on this, it's unclear if the time frame for the controller starts concurrently when the processor becomes aware of the breach, or when the controller actually has been notified of the breach by the processor. Another potential concern in the recent guidance is the inclusion of availability breaches as potentially reportable breaches. An availability breach, as defined by the guidance, is where there has been an accidental or unauthorized loss of access to or destruction of personal data. The Article 29 Working Party provides an example of a loss of availability as where there has been a significant disruption to the normal service of an organization, such as a power failure or denial of service attack, that then renders personal data to be unavailable, even temporarily. Specifically, the Article 29 Working Party states that an incident resulting in a personal data being made unavailable for a period of time is a security breach and should therefore be documented. Yet, depending on the circumstances, it may or may not require notification to the supervisory authority and communication to affected individuals. If the lack of availability of personal data is likely to result in a risk to the rights and freedoms of natural persons, then the controller will need to notify, and this will need to be assessed on a case-by-case basis. Now, this is a concern because in the U.S., an availability breach without any unauthorized access or acquisition of personal data is not considered to be a reportable breach. So these are points to keep in mind, and hopefully we will receive further guidance or clarification. Now let's compare the GDPR's breach notification obligations to the U.S. breach notification obligations. First, the categories of personal data and scope under the GDPR are much broader than under the U.S. Most U.S. data breach notification laws tend to cover information that make an individual susceptible to identity theft, whereas the GDPR covers all personal data, subject to the risk analysis that we discussed earlier. The definition of a breach is also much broader under the GDPR. The U.S. Typically requires notification if there's been an unauthorized access to or acquisition of covered information, whereas the GDPR defines a breach as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. And as we discussed earlier, the notification timeframes are also much shorter under the GDPR. In the U.S., the fastest notification timeframe for a controller is 30 days, and the fastest notification timeframe for a processor is 24 hours. Whereas under the GDPR, the controller must notify a supervisory authority without undue delay and, where feasible, not later than 72 hours after becoming aware of the breach. And it also has to notify individuals without undue delay. And a processor has to notify the data controller without undue delay. In the U.S., there are usually many more reporting requirements than under the GDPR, and this might be the one area where it's more stringent than the EU. For example, in the U.S., laws may require notification of credit reporting agencies, law enforcement, state attorneys general, and other state agencies in addition to the affected individual, whereas in the EU, notification is limited to the affected individuals and supervisory authorities. Finally, liability and fines. In the U.S., the bulk of liability comes from class action lawsuits, FTC enforcement actions, and state AG enforcement actions. Under the GDPR, fines for failure to notify of a data breach can reach 2% of global turnover, or 10 million euro, whichever is greater. However, keep in mind that this fine is simply for a failure to notify of a data breach. So if there was another violation of the GDPR that occurred in connection with the breach, such as a failure to have adequate security measures in place, then technically multiple fines can be issued. Finally, you'll need to review your vendor agreements to make sure you have appropriate data transfer mechanisms in place to transfer the data out of the EU. The good news is, that the current legal instruments that are being used to transfer data outside of the EU are generally maintained under the GDPR. So this means you can transfer data to a country with adequate protection or use an approved means of transfer, such as the EU model clauses. Although note that Schrems, who was the one that got the safe harbor framework invalidated, is also challenging the validity of the EU model clauses. You can also use binding corporate rules, but note that these are only applicable for intra-company transfers. You can certify to Privacy Shield, but these are only used for transfers to the US and not to other countries. You can also rely on a derogation, such as the unambiguous consent from a data subject, but these are very difficult to rely on. You can also seek approval from a DPA, and you can also rely on these new data protection fields under the GDPR. And a few quick notes about Privacy Shield. Privacy Shield is a replacement mechanism for the Safe Harbor framework after it was invalidated. Companies can self-certify to the Privacy Shield framework to permit transfers of EU personal data to the US. In order to be able to certify to the Privacy Shield, a company must be subject to the jurisdiction of the Federal Trade Commission or the Department of Transportation. So, for example, financial companies are not able to become Privacy Shield certified. Privacy Shield consists of 7 core principles and 16 supplemental principles. And as mentioned earlier, the onward transfer principle addresses how companies must protect the personal information that they transfer to other data controllers or third-party agents. It's also not easy to comply, since compliance often requires certain operational, policy, and contractual changes for a U.S. company. So how should you go about amending your contracts for the GDPR, especially if you have hundreds or thousands of contracts that potentially need updating? First, you should create a project plan for the assessment and renegotiation of your relevant vendor agreements. You should then assemble a team to manage and execute that project. The team can consist of internal resources as well as external resources, such as consultants and external attorneys. You should then identify the contracts that need to be remediated and prioritize those contracts based on the underlying risk. For example, how important are the activities or systems involved? And what is the type or volume of personal data that's involved? And do the services involve sensitive personal data? You should then determine how to execute the renegotiation of the relevant agreements. For example, can the agreements be amended using a template GDPR amendment, or must each agreement have custom amendments prepared? If your company's contracts are all based on the same template agreement, then it may be easier to create a template amendment that addresses the GDPR gaps. Has the vendor addressed any GDPR requirements in their latest documentation? That's another item to consider. How much negotiating power do you have with each vendor? For example, are the commercial aspects of the agreement due to be renegotiated shortly, or will the agreements expire before or after May 2018 when the GDPR comes into effect? Also, you might want to address other revisions in your amendment or renegotiation, particularly if the agreement is several years old and doesn't contain other standard privacy or security-related provisions, including to address compliance with non-EU privacy laws. For example, you might need to amend your agreements anyway to address the recent New York cybersecurity regulation for financial institutions. Finally, if you have a large number of contracts to amend or renegotiate and you have a team working on negotiating those documents, you might want to consider having a privacy playbook in place that documents preferred and minimum required fallback positions in order to comply with the GDPR and other requirements. Your vendor should also be equally motivated to have the contract amended to comply with the GDPR, since it might be subject to an administrative fine or other sanction if it doesn't comply with its obligations. And now I'll turn it over to Oliver.
Thanks very much, Lei. I think we have time today for one question, and we'll try and answer the others that we have received after the webinar. One question we received asked if the GDPR applies to EU citizens or residents, or whether a different application applies when you are monitoring individuals or where you are offering goods or services to EU individuals. Well, it's not based on citizenship or residency, it's based on whether you're offering goods or services or monitoring individuals who are located in the EU. There may in fact be citizens of other countries, but if they're located in the EU, that means you have to comply with the GDPR. So, with that note, That wraps up today's program. And on behalf of Mayor Brown and Lei Shen, thank you for your time. I hope you found this program useful. But be on the lookout for future invitations to our Technology Transactions webinar series. There are some final housekeeping items for today's participants. A recording and link to the materials for the program will be distributed by email in the next day or two. And if you are applying for CLE credit, please note that certificates of attendance will be distributed within 30 days of the program date. If you've got any topic ideas for future programs, please email us at techtransactions@mayorbrown.com. Thank you very much.